Our citizens who were detained have finally returned home, but many challenges still lie ahead. Reporter Kang, we urgently need to address the visa issues moving forward. One of our workers was detained and later released, while another is still in custody. Looking more closely into their visa situations, it appears that some had valid work permits.
There are several types of visas usually issued when traveling to the U.S. This includes the electronic system for travel authorization, short-term visas like B1 or B2, visas for skilled professionals such as H-1B, and work authorization documents like EAD. According to officials, many of those detained held ESTE or B1 visas, which caused the issues. However, according to the data we obtained from Congressman Han Jong-ai's office, out of the 317 detained citizens, 170 had ESTA, 146 had B1 or B2 visas, and the remaining one had an EAD, which is a work permit.
So this person is the one who is still currently in the US. They even had a valid work permit. Doesn't that make their detention completely unjustified?
For that reason, it appears possible to file a lawsuit against the US government seeking compensation. Experts suggest that not only this individual but other detainees as well might have grounds for lawsuits, particularly concerning procedural issues during their arrests. This is because it appears that our citizens' alleged offenses were not specified in the search warrants and that excessive use of authority was evident, such as the use of chains during the arrest process.
If they were arrested without sufficient grounds for allegedly violating the law, a lawsuit seeking compensation could potentially be filed to formally address violations of their constitutional rights.
However, considering our company's future local activities and key bilateral relations, whether lawsuits will proceed remains uncertain.
In that case, compensation could be considered. However, at this point, the US is requiring a stricter visa system, with the Secretary of Commerce insisting proper visas be obtained.
Our authorities announced the news of the release, stating that there would be no issues with re-entry in the future and that they would also push for working-level discussions to establish a new visa. However, as you mentioned, a significant statement was made by a senior US official regarding this matter. Howard Lutnick, U.S. Secretary of Commerce, emphasized that South Korean companies must obtain proper visas to send their workers to the U.S. successfully. He added, "If issues arise, just call me. I'll contact the Secretary of Homeland Security responsible for immigration matters."
I'm not sure whether we can trust that the Secretary of Commerce can resolve the visa issues. When he says to obtain proper visas, does that mean the previously issued visas are no longer valid?
As you mentioned, the message can be interpreted as requiring entry with visas that have no potential issues, such as work authorization documents or visas for skilled professionals. However, obtaining these specialized visas within a short period is limited. Sure, Minister Lutnick boasted about calling the Secretary of Homeland Security, but the Department of Homeland Security, which actually handles immigration issues, might take a much tougher stance. On this matter, the Ministry of Foreign Affairs Cho Hyun explained that, thanks to President Trump's special directive, statements from other departments have become irrelevant, and visa-related practical discussions will begin promptly.
That concludes our discussion. This was political correspondent Kang Young-ho.